this golden opportunity to share my knowledge, about this arbitration, conciliation and mediation and the amendment of the Arbitration Act and thereon. ಇದರಲ್ಲಿ ಕವರ್ ಆಗಿದೆ.
ಓಕೆ, ಕನ್ನಡದಲ್ಲಿ
I think you are comfortable in both the language, Kannada and English. To commence this lecture on this Arbitration and Conciliation Act, we must know something which is indifferent. Why this arbitration is required when the vast and substantial law is there, like Civil Procedure Code, Criminal Procedure Code, other ancillary laws, amendments are there in existing. Why this arbitration and conciliation is so much importance, or why the central government and the judiciary is giving so much importance to this arbitration nowadays, is very important to make note of certain things. Even though it is a budding stage, arbitration is not popular, is not effective when compared to Civil Procedure Code. Everybody wants the justice before the civil court only, or the High Court, or the Supreme Court. But nowadays, the popularity is being raised, is being get on this arbitration also, as good as mediation. Mediation, there is no such law existing, there is no such amendments or the act which specified by the central government. But it is going on. They will make one act shortly. Only rules are there in mediation. Whereas in arbitration, it is as good as Pre-Independence Act. 1940. First Arbitration Act was there in 1940. Subsequently, regularized, made substantial improvements in 1996 Act. Thereon, after this 1996 Act, so much of loopholes are there. To fill up that one, this 2015 amendments was made. Arbitration and Conciliation Amendment Act, Amendment 2015. And even the left out, residual, they made it in 2019. Over that cap, a feather is made it by the central government, like NDIAC also. There is a feather on the cap. So first 1940, then 1996, thereon 2015, subsequently to that 2019, and one feather, small. That is the NDIAC. These are all the way that is appearing in this arbitration and conciliation. Earlier there was no conciliation. They made it by influence, by Europeans, by Germany and all these countries. They are very much interested in conciliation, and they influenced India also for some of the official administrative purpose. They made it this conciliation, and they made it in the Arbitration Act after this section 65 and onwards. That conciliation also it's incorporated in the law. I am not going into the conciliation because it is not at all popular and it is nowhere it is existing. Nowhere it is existing. Nobody wants this conciliation. Everybody wants either arbitration or mediation. Either arbitration or mediation, not this conciliation. I think I am making myself clear about this. Why I am giving importance to this, deviated towards arbitration than conciliation. Arbitration Act is a very hard subject, but after that, once you become the arbitrator, you will be flourished. You will be more comfortable being an arbitrator than the mediator or the conciliator. It's a commercial business. It's a commercial profession. Nowadays, arbitrators are minting money. In Western country, this is the introduction that I am giving before going into the amendments and all. Why? Because first we must know what is the practical application of this arbitration, mediation and everything. Otherwise, just academically, if we go into the depth of this issue, there is no use, much use in future days for your career or whatever. If you become the judge, after this profession or after this designation as a judge, after get retirement, if you are getting retirement after this judicial post, then there is a vacuum creates after this job, after this judiciary. You must have some substantial profession to earn, that is the arbitration. And in Western countries, every building near the judiciary, they have 2 floors. Ground floor, our advocates are there. They put that board, that is, we are the advocates and solicitors. Above that floor, there is one more board, that is the mediator and an arbitrator usually. If anybody goes to a civil dispute to get the remedy, if a client goes to the advocate, just he says, don't come and file the petition before any courts. In Western countries, I am telling, in New Zealand, in Australia, he says, go upstairs. First you go to the mediation, settle this dispute, that is 60% cost. Here 100% cost. And you have to pay for second time reciprocation. First time it is free. Next time I will open this clock, put the clock on, and you must pay for that. Even mediation also same, but it is 50% reduction is there in the cost. If you pay 10 lakhs to the mediation, you must pay 25 lakhs here. Therefore, first you go, get remedy, get relief from this mediator. There is a special technique. They are all well equipped with this mediation process or the arbitration process. Then you come back if it fails. That is the trend created in Western countries. Australia, New Zealand and everywhere it is there. In India also it is now practicing. The advocates are practicing. They are well within the ambit of this mediation techniques, arbitration techniques, and then they are leaving behind this civil procedure or the petition or to go to the court as jurisdictional, what the customized civil disputes are there, they are not going. Just they want mediation technique to be implemented, and they are minting money in mediation also. In arbitration also, not in the civil cases and all. As you know, As an advocate, you know, if a party comes to you, they will give some money, say 1 lakh, and you don't have mouth to ask once again till the case disposed. But in arbitration, every sitting you must pay. That is the funny of this arbitration. In mediation, every sitting you must pay. And the quantum, it is depending on the quantum. But in civil dispute, if you file, they will not pay on the basis of quantum. 10% on the value, 20% on the value, they will not pay. Just they pay 1 lakh rupees, case nadsta iri Swami nodkolloda. So that is the word they say. Amel kortini. Once they get award, they will not come to you, just they will engage one more advocate to get the certified copy of the order. But here, in this arbitration, till you get the award, you will be on. You will be put under pressure to pass the award. And if they pay, you will pass the award. Otherwise, just you take the time to qualify that settlement. Unless they pay entire arbitral fees or the mediation fees, they will not pass order. They will not issue the order. The draft they will show, oh, this is the order I will pass, this is the award I will pass. But it will not be circulate. That strict measure is there regarding the arbitration and the mediation also. This arbitration, conciliation, mediation, judicial settlement, everything comes under section 89. As it is amended in 2002, Civil Procedure Code. You know that whenever a case comes to the court officer or the jurisdictional officer or the civil judge or the judge has power, has empowered, has power to send the petition or the suit or the application before arbitration or the conciliation or the mediation or the judicial settlement like Lok Adalat. Whenever he feels, deems fit the case, he will refer this matter to the proper settlement resolutions, dispute resolution system or dispute resolution technique. We say it's a technique. It's a special circumstance that one must get acquainted with these procedures. Therefore, a person, if I refer this matter, if the judge sends the matter to the mediator or the mediation center or the arbitrator, he knows that this prayer, this facts, this text, this pleading is quite cornered. This is fit for mediation or the arbitration or the Lok Adalat or whatever. If he feels fit, if he deems fit, or if he considers the entire petition, if he reads at a stretch, okay, it will not the case, or it is not the case for any resolution, we must keep, and the evidence or the civil procedure has to be undergo. This is not the fit case for arbitration. This is not fit case for the mediation. I have to get into the civil procedure code or the procedural factor of the civil procedure. Then he will retain that case. Therefore, discretion is depending on the court officer or the judge to use section 89. Even parties or the counsel of the parties may request the judicial officer, principal judge or whoever the judges may be, request the judicial officer to send this suit for mediation or the arbitration or conciliation or whatever. He can. Once again, judge has power to reject, to accept, to modify under section 89. He has empowered. He has power to judge the petition whether to go for the resolution. If it fails, or if he deems fit, if he considers it is not for anything, then he can put into the scroll about the civil procedure code. Why I said section 89 is an efficacious way to settle the disputes. What the word says, wording is there. Either arbitrate or mediate or conciliate, but don't go for this litigate. Don't be a litigate. Either you go for mediate or for conciliate or for arbitrate, but don't go for as a litigate. Don't be a litigate. So that is the word they say. Under this Arbitration and Conciliation Act, earlier during that's the 1940 Arbitration Act, there is large loopholes found in the act. There was no such efficacious remedy available in the arbitration. There is no specific definition for arbitrator. There was no definite definition for the court. There was no definite definition for the place of arbitration, and international or the domestic arbitration is not defined clearly. Therefore, there was a necessity to make entire reshuffle of the Act of 1940, that is 1996 Arbitration and Conciliation Act. Conciliation also included in the Act and enacted as it given in 1996. Therefore, that Act superfluous, and it was in effect up to 2015. But later also it was effective. It is effective now also. But some amendment they made it in 2015 to make it fit, to make it substantial, to make it a success, to make it an effort to adjudicate, to make use of everything, the sections and their procedures into the depth and the critics of the Act and amendments. I mean to say, 1996 Act was clear. All the definitions, everything, everybody appreciated, judicial authorities appreciated, arbitrators appreciated, but there was a loophole while making a submission about extension of time, passing the award time limit. There was no time limit while passing the award. They can take even 3-4 years also. And there was a clash, there was a conflict, section 9 and section 17. There was a clash between the civil court and the arbitrator. Immediately, if any dispute comes, he will rush to the court and apply section 9 application and gets the stay interim order immediately. And arbitrator has to wait like a Jataka Pakshi. Unless this interim order clears, nothing has to be done before the arbitrator. Arbitrator was sleeping for years together because of this interim order. And this loophole, this mistake, this deficiency observed by the central government after thorough discussions, debate, those circulars or the speeches or the lectures and notes, objects, everything. In October 2015, 23rd of October 2015, all these mistakes, all these loopholes entered into the 1996 Act, made it as amendment. One more act, that is Amendment Act. In 2015, 23rd October, objects and reasons were passed in the Lok Sabha. Then the Parliament has given assent, there has given accord to this, and President has given assent on December 31st of 2015. Therefore, what I mean to say, Arbitration Conciliation Act 1996 was thoroughly amended, thoroughly changed to fill up the loopholes and made it absolute 31st December 2015. That is the Amendment Act. 2015 Amendment Act. In this amendment, I said earlier in 96, this arbitrator was sleeping just because of interim order is there in section 9 application before civil court. Civil judge, you know that civil judge how there is a training, then the civil judges will go to the judicial academy to get the training. 6 months, 7 months, nobody is there in the court. And counsels, immediately they rush and get the adjournment for no reason. They will grant. There is a delay in the proceedings. There will be a delay unnecessarily. And arbitration matters. There is a commercial. Arbitration is a commercial. In rural, there is no such arbitration going on. As you know, we cannot do in Anekal. In Anekal or in Nelmangala or somewhere else, in Jigni or where there is a industrial, where there is a industrial suburban is there, sub area is there, we can get some cases of arbitration, but not in the residential area or the grey area where simply the civil disputes are there. There is no use of arbitration in the towns, in taluks, even in other districts. Like metro city, Hubli, and even Mysore, certain extent, Mangalore, Bangalore are the cities where arbitration are welcome by the judicial officers or the arbitrators or the people. Where these are all commercial disputes. As you know, commercial disputes are the white collar conflicts. Commercial disputes are white collar conflicts. Just they want money back. There may be a due of crores and crores of rupees held up in the bank, held up in the capital, held up in the raw material, held up in the work in progress, held up in the tender or the contracts. Those things has to be reworked, reinforced, get into the channel, get back their money. Is the portfolio of this arbitration. Therefore, if section 9 application is there for 3 years, their funds will be locked in somewhere else. And some of the raw materials like tomato. If tomato is there in the street without any sale or some sale disputes are there, one can get within 10 days or 15 days, otherwise the tomato will be spoiled. Will be rotten. Eggs also will be rotten. Those things will be qualified or discharged in this arbitration immediately. One can get interim order by this arbitration process. Civil Procedure Code, nothing will be done unless the notice will be issued to the opposite party. Opposite party has to file the objection. There is a counter. After that, the judge may say, okay, I will examine. He will pass the whether interim order or not, we don't know. And the emergent note will be issued to the opposite party. For many months, the emergent notice will be in the road only, in the transit only. It will not be executed. Those things, it has to be eradicated. It has to be removed substantially or make it useful for the commercial persons, commercial establishments. Therefore, this amendment was made in 2015. What is that amendment? There are certain sections which was immediately to be amended in 2015. Those sections are Section 2. First is Section 2. Second, Section 8. Section 8. Section 9. Section 17, Section 24, Section 29, Section 29A, Section 34, Section 36. These are all very important sections of amendments of 2015. Section 2, Section 8, Section 9 of arbitration amendments. Amendments were made in 2015. Section 2, Section 8, Section 9 17, 29, 34 and 36. I will go through one by one why it is necessary. Even before reading these important clauses or the sections, it is very important to make it to pass on some messages to you, the future judges. One is public policy. Even Renu Sagar cases, Patel engineering cases, those are all Supreme Court held that the definition of public policy has to be reviewed immediately. Number one. In Patel engineering case, about who is the arbitrator. Section 11, very important section in the amendment is section 11. Who is the arbitrator? Why we should appoint this arbitrator? Whether international arbitration is applicable or not, domestic arbitration is applicable or not. Who has to appoint the arbitrator? Whether the Supreme Court or the High Court, whether the judge or the Chief Justice. There was a confusion. Therefore, this amendment was made. The first word I want to repeat is public policy. Everybody under section 34 and 36, they rush to the court and get the stay because it affects the public policy. Therefore, Supreme Court granted stay immediately without looking into the matter because of public policy, the word public policy. Then they defined in Renu Sagar case what is the public policy and all. And even appointment of arbitrator, second. Who has to appoint the arbitrator? Whether institution designated can be appointed, can be overlooked. Whether the Supreme Court judge has a power than the other judges. Those are all questions arose in many cases. Like a few cases like aluminum, that is Bharat aluminum case, where definition of this arbitrator, who has to be arbitrator, was questioned, and thereon the remedy granted by the Supreme Court, and it is enacted now in an amendment. Why these cases are very important? Why these cases are important before the Supreme Court? So just one cannot go to the Supreme Court just to get fame and name. The lawyers cannot go to the Supreme Court. If the judges see the ambit of case, the crux of the case, the text of the case, and the summary of the issues, they will pass on the message to central government to amend it. These things happened in those cases. Even saw pipe case also. The question of arbitrator was there. Therefore, the central government, after passing the judgment by the Supreme Court, they made it clear and passed the message to central government to amend it. Therefore, I want to read certain paragraphs where these amendments were made and the substance, why this summary is required, why it is so important in amendment. ನಮ್ಮ ಆರ್ಬಿಟ್ರೇಷನ್ ಅಂದರೆ ಕನ್ನಡದಲ್ಲಿ ನಮಗೆ ಯಾವಾಗಲೂ ಸಮಸ್ಯೆ ಬರುತ್ತೆ. ಏನು ಮಧ್ಯಸ್ಥಿಕೆನ ಮಧ್ಯಸ್ಥದಾರಿಕೆನ ಅಂತ. ಮಧ್ಯಸ್ಥದಾರಿಕೆ ಅಂದರೆ ಏನು, ಮಧ್ಯಸ್ಥಿಕೆ ಅಂದರೆ ಎರಡು ಒಂದೇ ಅನ್ನುವಾಗ ಇದು ಇವರು ಮಾಡಿದರು, ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಇಂದ ಕಳಿಸಿದಂಥ ಒಂದು ಆ ನಿಯೋಗ, ಅದನ್ನು ಬ್ಯಾಂಗ್ಳೂರು ಮೀಡಿಯೇಷನ್ ಸೆಂಟರ್ ಅಂತ, ಅದನ್ನು ಬೆಂಗಳೂರು ಮಧ್ಯಸ್ಥಿಕೆ ಕೇಂದ್ರ ಅಂತ ಮಾಡಿದರು. ಡೆಫಿನೇಷನನ್ನು ಅವರು ಓದಿದ್ದಾರೆ, ಚೆನ್ನಾಗಿ ತಿಳ್ಕೊಂಡಿದ್ದಾರೆ. ಮಧ್ಯಸ್ಥಿಕೆ ಅಂದರೆ ಮಧ್ಯ ಕೂತ್ಕೊಂಡಿರೋನು, ಮಧ್ಯಸ್ಥದಾರಿಕೆ ಅಂದರೆ ಇವರಿಬ್ಬರನ್ನು ನಾನು ತಗೊಂಡು ಹೋಗೋನು. ಮಧ್ಯಸ್ಥದಾರಿಕೆ ಅಂದರೆ ಮಧ್ಯಸ್ಥ ದಾರ, ಮಧ್ಯಸ್ಥಿಕೆ ಸುಮ್ಮನೆ ಮಧ್ಯಸ್ಥಿಕೆ, ಅವನು ತಟಸ್ಥ, ಅವನು ನ್ಯೂಟ್ರಲ್, ಅವನೇನು ಪ್ರಯೋಜನ ಇಲ್ಲ. ಯಾರು ಮೀಡಿಯೇಟರ್ ಅವನೇನು ಮಾತಾಡೋಂಗಿಲ್ಲ. ಹೈಕೋರ್ಟು ಒಂದು ರೂಲ್ಸ್ ಮಾಡ್ತು, ಅವಾಗವಾಗ ರೂಲ್ಸ್ ಮಾಡ್ತಾ ಇದೆ ಅದು. ಯಾಕಂದರೆ ಅದು ತಪ್ಪು ಮಾಡ್ತಾ ಇರೋ ಮೀಡಿಯೇಟರ್ಸ್ ತಪ್ಪು ಮಾಡ್ತಾ ಇರ್ತಾರಲ್ಲ, ಅದನ್ನೆಲ್ಲ ತೊಗೊಂಡೋಗಿ ಒಂದು ರೂಲ್ಸ್ ಮಾಡಿ ಮತ್ತೆ ಕಳಿಸ್ತಾರೆ ಸರ್ಕ್ಯುಲರು. ಯಾಕಂದರೆ ವಿಪರೀತ ತಪ್ಪು ಮಾಡ್ತಾ ಇರೋರು ಮೀಡಿಯೇಟರ್ಸು, ಡಿಸ್ಪ್ಯೂಟ್ಗೆ ಹೋಗಿರೋ ಕ್ಲೈಂಟ್ಸ್ ಎಲ್ಲ ಅಥವಾ ಕೇಸಸ್ ಎಲ್ಲ, ಕೇಸಸ್ನಲ್ಲಿ ಮಾಡೋವಾಗ ಇವ್ರು ಮಾಡೋ ಮಿಸ್ಟೇಕ್ಸೇ ಅದು ರೂಲ್ಸ್ ಮಾಡ್ತಾ ಇರೋದು. ಆ್ಯಕ್ಟು ಹಾಗೆ ಆಗಿರೋದು. ತಪ್ಪು ಕಂಡಿಡಿದು ಎನಾಕ್ಟ್ಮೆಂಟ್ ಆಗ್ತಾ ಇರುತ್ತೆ, ಮಾಡಿಫಿಕೇಷನ್ ಆಗ್ತಾ ಇರುತ್ತೆ, ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗ್ತಾ ಇರುತ್ತೆ. ಅಮೆಂಡ್ಮೆಂಟ್ ಯಾವಾಗ ಆಗುತ್ತೆ? ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಬರುತ್ತೆ, ಒಂದು ಲೆಂತಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ನಡೀತಾ ಇರುತ್ತೆ, ಆಮೇಲೆ ಆ ಜಡ್ಜ್ಮೆಂಟ್ನಲ್ಲಿ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡ್ತಾರೆ. ಇದೆಲ್ಲ ಸೆಂಟ್ರಲ್ ಗೌರ್ಮೆಂಟ್ ಅಬ್ಸರ್ವ್ ಮಾಡಬೇಕು, ಇದು ಹಿಂಗೆ ಬಿಟ್ಟರೆ ಹೇಗೆ ಅಂತ. ಆವಾಗ ಸೆಂಟ್ರಲ್ ಗೌರ್ಮೆಂಟ್ನವರು ಹೌದೌದು ಇದನ್ನು ಅಮೆಂಡ್ ಮಾಡಬೇಕು ಅಂತ ಅದನ್ನು ಅಮೆಂಡ್ಮೆಂಟ್ ತಗೊಂಡು ಪಾರ್ಲಿಮೆಂಟ್